Okay, I think we can start. If that's fine with everybody, I would like to say a big welcome. So, Your Excellencies, ladies and gentlemen, dear colleagues, I'm Barbara Burnett. I'm the Secretary General of the Association for the Prevention of Torture, a Geneva-based NGO. And together with the co-organizers, the African Policing Oversight Forum, known as APCAF, and the Norwegian Center for Human Rights, as well as UNODC justice sections, it's really a great pleasure to welcome you today to this side event entitled Implementing the New Principles on Effective Interviewing for Investigations and Information Gathering Towards Better and Fairer Administration of Justice. So as the title indicates, these principles on effective interviewing are new, and these sessions of the Crime Commission is really timely. And in fact, this side event is the first public event where we can present and share these new principles on effective interviewing. So we can share the text, and it will be shared on the chat with everybody. You can find the link. And we will be able to discuss as well about the next steps, and in particular focus on the possible implementation of these principles. The drafting of the principles on effective interviewing was quite a long process, and actually it started back in 2016 following the call by the UN former Special Rapporteur on Torture, Juan Mendes, who called for a protocol to move away from coercive interrogation and forced confession and replace them by report-based interviewing, as well as the implementation of associated safeguards. So the drafting itself was an expert-driven process led by a steering committee of 15 experts, men and women from different regions and different fields of professional background, ranging from law enforcement, human rights law, psychology, and intelligence, and including Sean Tate from APCAF, who will be speaking later today, and we also have some participants from the steering committee. So the steering committee adopted the final text of the principles on the 6th of May, and we also call them the Mendes principles. So the process was quite long, but the process itself was already acknowledged and welcomed by and supported by various UN bodies, including an important paragraph 47 in the Kyoto Declaration adopted at the end of the UNODC Crime Congress recently in March. So these principles are really a key document that will assist the state authority to improve the effectiveness, but also the fairness and especially the outcomes of investigation, while at the same time protecting the human rights and the dignity of all persons interviewing. So we will look at these principles, and we will be able to discuss in the next hour together. And we have divided the side event into two segments. First, we will look more at the normative framework of the principles, especially for law enforcement and human rights. And here we will be hearing the ambassador of Norway, as well as APCAF. And then we will have a second segment that will focus more on exploring avenues for implementation. And we will have intervention by the ambassador of Ghana, by UNODC and the Norwegian Center for Human Rights, as well as Interpol and YEPCO from Nairobi. And the closing of the side event will be done by the UNODC Deputy Director. So we will also have time for questions, and we suggest and we recommend that you use the Q&A to put questions in writing, and we will try to answer them during the last quarter of the session. And maybe if we have a bit more time, we can also take some live questions. I also would like to mention that the side event is recorded, and I hope this is fine with everybody. So I think without further ado, I would like to start now the first segment, looking at the normative framework, and give the floor to Ambassador Andersen, the ambassador of Norway to the UN in Vienna, who will speak about strengthening the normative framework. And I would also thank Norway for the leading role in negotiating the paragraph 47 in the Kyoto Declaration. Ambassador, you have the floor.
Thank you, Barbara. Thank you so much. Excellencies, ladies and gentlemen, dear colleagues, friends. I will start by thanking you, Barbara, and the Association for the Prevention of Torture and partners for organizing this event and also for inviting me to speak. Norway welcomes partnerships between APT, UNODC, APCOF and the Norwegian Center for Human Rights. This is exactly the kind of approach, the multi-stakeholder partnerships and police and justice cooperation that are at the core of our work here in Vienna. And I have to say that even though the process of drafting the principles has been long, it's also very impressive, bringing together a wide variety of experts from so many relevant fields. Now, all criminal justice systems consist of a number of government agencies and institutions with many different tasks. Justice is served through a long chain of events. It's evident that a criminal justice system is not stronger than the weakest link in this chain. In recent years, we have become increasingly aware that a main weakness is often found in the way law enforcement representatives communicate with suspects, witnesses, and victims during interviews and court proceedings. All countries have had to face cases of miscarriage of justice that have had catastrophic consequences for those involved. Yet we have been slow in analyzing the reasons, all too often accepting such cases as rare exceptions in otherwise well-functioning systems. While great achievements have been made in developing technical tools for law enforcement and in many parts of forensic science, there has not been the same scientific approach to understand the process of interviewing. The principles presented today are applicable to all our criminal justice systems. They can only be described as game changers, a strong reminder for policymakers and authorities to take a closer and more critical look at how interviews are conducted and to find ways for improvement. The real strength of the principles lies in how well they show that criminal justice systems do not gain from abusive interviewing practices. On the contrary, such practices are counterproductive and ineffective and undermine trust in society. Changing institutional cultures and mindsets take time. And in many criminal justice systems, implementing the principles will meet challenges at various levels. For policymakers, there is an urgent need to pave the way by making changes in domestic law, regulations, training techniques, procedures, and practices. So, to sum up a little bit and conclude, Norway welcomes the partnership between the UNODC and the Norwegian Center for Human Rights to develop e-learning modules on effective interviewing, which will allow the practical implementation of international standards and the new principles. Changing police culture and practices require long-term efforts and investment in laws, policies, practices, and training. The UNODC and the NCHR have long-standing experience in supporting member states in this regard. Thank you so much. I look much forward to the rest of the seminar.
Thank you very much, Ambassador. Understand for the this important intervention, and I think there are key points about partnerships, and this will be key in the future as well. But also considering the criminal justice system as a chain, and mentioning that principles can be a game changer for reinforcing one of the weakest functioning elements of this chain, law enforcement interactions with suspects. Thank you very much. I now give the floor to Shante, who is the director of APCOF, and you will present a bit more the principles and the normative framework. Sean, you have the floor. You have to unmute, sorry.
My apologies for that. Thank you very much for the opportunity to participate in this webinar and to co-host it with our colleagues at the Norwegian Institute and the Association for the Prevention Against Torture and UNODC. As the chair mentioned, we had the privilege to work with the steering committee on the development of this document, the principles, and really, you know, what I'd like to say is that this certainly supports our vision as an organization working for human rights and accountable policing in Africa and across the full spectrum of accountability. So that means that it engages with both the issues on the reactive side of accountability. So that is the systems in place to support effective supervision, complaints management, investigation into alleged police criminality or either administrative or disciplinary procedures, but also the proactive aspects of accountability, which relates to issues around law reform, standard setting, policy inputs and training. And it's in this latter environment where we're certainly, we're constantly told that while we do have very good law, very good treaty, very good processes in place, it's the implementation that is often lacking, it's the implementation that is weak. And we, together with the co-organizers on this panel, have invested considerable resources over the past years at international, continental, regional, and local level in supporting human rights implementation. Now, what we've come to realize is that there's an enormous benefit in being able to translate high-level human rights obligations into text that is understandable, fit for purpose, and can guide implementation by mandate holders at that point of service delivery. And this is where the principles on investigative interviewing really come in. I mean, the first point that I want to emphasize when it comes to this set of principles and their support of the implementation of the normative framework is to go back to one of the articles that I think was at the heart of taking a process like this forward. And that is Article 11 in CAT, which provides that each state party should keep under systemic or systematic review interrogation rules, instructions, methods, and practices, as well as the arrangements for custody management and treatment of persons subjected to any form of arrest, detention, or imprisonment in the territory or under their jurisdiction, with a view to preventing cases of torture. The international rights community until now hasn't provided the substance on what needs to guide this in a manner that recognizes the evidence, the practice, and the procedural safeguards. And this is really at the heart of this, the enormous value that these principles on effective interviewing for investigations and information gathering provide. As the ambassador mentioned, it's been a long road, but this is not an easy task, because any commentary such as provided by these principles needs to be relevant across multiple environments to which the issues apply. It needs to balance the detail and the specificity along with generalization. It needs to maintain the right standards set out, not only by CAT, but all related standards, guidelines, commentaries, treaties, and protocols that are applicable. It needs to be applicable across all the mandate holders mentioned: law enforcement, civil, military, medical personnel, public officials. And it needs to be cognizant of the common law and civil legal traditions. And then finally, it needs to be presented in a way that is accessible and is usable to the practitioner, wherever they may find themselves, even if this is in the most resource-constrained environment. And this, I believe, the principles on effective interviewing do. they developed in the form of a principle which at their core provide a shorthand, much like a code of conduct, to translate what is complex human rights obligations and practice into provisions that are easily understood and universally acceptable. The key principles, and as they've been identified, are at the heart of an effective rights-based interviewing for investigations and information gathering. And they're distilled from fundamentally two sources. The one is the legal principles relevant to human rights compliant interviewing, as they're firmly anchored within international law and drawn from treaty law, customary international law, jurisprudence in terms of how this is interpreted for local application. And the other is the overwhelming scientific evidence now available to us on the effectiveness of an interview-based process, such as this document underpins, for those seeking the truth and facts, and seeking that in a manner that will hold up to legal scrutiny. So at a glance, these principles, irrespective of the discipline or the legal tradition within which one finds itself, advise that if you base your interview practice on the scientific evidence available and you underpin it with the internationally agreed procedural protections, and you understand and plan for an interview process that reaches from the earliest engagement with the official right through to the finalization of that process through its review and assessment. If you're particularly mindful of vulnerability, if you recognize that interviewing is not an ad hoc task, but it's a skill and a profession that must be effectively trained for and supported, if you provide for the relevant means of supervision, monitoring, and accountability, and then if you align your legal and domestic frameworks, regulatory systems, and organizational practice accordingly, then you're more than likely to be on the right path when it comes to the review of your processes in line with obligations such as provided by CAT. So the principles set out for successful practice for interviewing an integration of scientific research, legal standards, and ethical duties. And this is set out in broadly three areas. So principle one is to base your practice of on evidence, and sets out the foundations for interviewing that integrates scientific research, legal standards, and ethical duties. The next series of principles speak to practice. Principle two recognizes that effective interviews combine evidence-based practice with the associated safeguards from the outset of the process right through to its conclusion. Principle three emphasizes the need to take vulnerability into account. And I think here the principles for effective interviewing provide a significant value to practitioners in this discussion on vulnerability set out in principle three. It identifies the interview itself as a situation of vulnerability and the safeguards required to be able to address that. But it also goes further and recognizes that there are persons that can find themselves in situations of heightened vulnerability, and these require the appropriate responses via being able to do those risk assessments and then introduce the mitigation strategies and processes involved. Principle four maintains, as I said earlier, that interviewing is a skill and it's a profession. And as such, it requires specific training and it requires continuous professional development. And without this investment, we're constantly going to be hamstrung in terms of the effectiveness of our interview processes and the extent to which they accord with international safeguards, procedural protections, etc. Principle 5 confirms that all our efforts need to be underpinned with the ability to be accountable and to be held to account. And this includes recognizing the need for the necessary institutional procedures to be put in place, the regular review of these procedures as provided for in Article 11 of CAT, the importance of effective record keeping, reporting internally, but also externally to independent oversight bodies, the importance of independent monitoring when it comes to particularly custodial facilities, the importance of complaints mechanisms, investigation and investigation practice, and issues around and the importance of redress and reparations to be available. And then finally, the third area, which is set out in Principle 6, really kind of understands the importance of the member state obligations via the effective and comprehensive implementation of these principles. And it reflects off the implications for implementation within domestic legal frameworks, within the institutional culture of the organization, within the capacity of the organization, and the relevance of these principles for judicial authorities, the importance of dissemination. And in this way, it loops back to providing insight into how we address this seemingly perennial challenge of implementation of the rights obligations, which I mentioned earlier. So, Barbara, thank you very much. I'm going to hand over to you.
Thank you very much, Sean, for this excellent presentation and also for the overview of the 6 principles. I think this is very useful. As I said, this is the first time we can really present them, but also emphasizing that actually it's not so much a standard setting exercise, but rather a standard translating exercise, if I can say so, translating existing obligations into practical, accessible, understandable, and useful tips for the practitioners. And I think this was a very important message. And I also want to say that you were really key in transforming the text into these 6 principles, and your role was essential in the steering committee in this regard. I now propose that we move to the second segment of this side event, which is focusing more on exploring avenues for implementation. Now that we have the text, what shall we do with them? And we will here listen first to a video recorded message from the ambassador of Ghana in Geneva, Ambassador Cleland, in the name of the Convention Against Torture Initiative, CTI. And then we will listen to UNODC, but I will mention the next speakers as they come. Alexia will put the video.
Excellencies, distinguished speakers and participants, ladies and gentlemen, on behalf of the 6 governments spearheading the Convention Against Torture Initiative, namely Chile, Denmark, Fiji, Indonesia, Morocco, and my own country, Ghana, I am delighted to be speaking at this side event today. Let me start by thanking the organizers, the Association for the Prevention of Torture, a key partner of CTI, the African Policing Civilian Oversight Forum, the Norwegian Center for Human Rights, and the Justice Section of UNODC for inviting me and for putting together this very timely and important event. Since 2014, the CTI core states have been leading a 10-year global and cross-regional initiative supporting states through confidential dialogue, exchange, and experience sharing towards ratification and implementation of the UN Convention Against Torture, with a view to achieving universal ratification of the Convention and improved implementation by 2024. CTI has made it one of its key strategic priorities to support states in their torture prevention efforts through the implementation of safeguards against torture and ill treatment in the first hours of police custody, including on investigative interviewing techniques. CTI has held regional seminars where states have shared their experiences and challenges in implementing safeguards against torture and ill treatment. and we have regularly received requests for further training and awareness raising on the benefits of non-coercive interviewing techniques. Last month, Ghana hosted a professional online training workshop in which CTI partnered with the Norwegian Center for Human Rights and the Committee for the Prevention of Torture in Africa, gathering senior representatives of the police service and criminal justice system of 5 West African countries, alongside major international experts in policing, forensic psychology, and torture prevention. The workshop created the platform for those of us in West Africa to engage with senior police officials and justice policymakers on how we can move away from coercive interrogation methods and embrace investigative interviewing, which allows police and law enforcement to gather accurate and reliable information, even as it reduces incentives to resort to coercive interrogation methods and decreases risk of false confessions and allegations of police misconduct. The workshop illustrated the considerable interest in effective interviewing and the equally considerable capacity for change that resides within law enforcement agencies. Ladies and gentlemen, I welcome the completion of the principles on effective interviewing for investigations and information gathering, which can provide a normative base for the implementation of non-coercive interviewing and reliable information gathering, a key element in fighting crime. I therefore trust that the implementation in practice will lead to better outcomes for investigations and at the same time, a reduction in the risk of torture and other ill treatments. Lastly, it is good to remind ourselves that the UN Convention Against Torture requires states to systematically review interrogation methods and practices with a view to preventing acts of torture. The new principles, therefore, should assist state parties across the globe to move one step further towards the eradication of all acts of torture, prompting reviews of police questioning methods and supporting broader police reform efforts domestically. I thank you for your attention and I wish you a fruitful and successful event.
Yes, we are grateful to the CTI and the ambassador of Ghana, and they underline again the message of implementing with the principles already existing obligations, especially Article 11 mentioned by Sean as well. And I think in the future, the cooperation with the CTI will also be key for the implementation of the principles. And we are looking forward for this continued cooperation. I'm now happy to give the floor to Mikaela Markova from the UNODC, together with Gisle Kvenvik from the Norwegian Center for Human Rights, who will present and discuss the UNODC e-learning tool on investigative interviewing. Mikaela, you have the floor.
Thank you, Barbara. Your Excellencies, ladies and gentlemen, dear colleagues, as we have heard from previous speakers, implementation of the principles on effective interviewing is a complex undertaking. In line with UNODC's mandate to provide technical assistance to member states in the area of police reform in line with UN standards and norms, UNODC is ready to continue to support law enforcement and other criminal justice actors in their efforts to implement the principles on effective interviewing. UNODC can specifically provide legislative advice in bringing the domestic legislation in line with international human rights obligations and other standards, as also reflected in the principles. Develop tools and guidance materials to law enforcement and other criminal justice actors based on international best practice and standards, as well as provide training and other capacity building activities to states' investigatory authorities, including those investigating complex crimes such as terrorism and trafficking in human beings. As Sean already mentioned, and as per the Principle 4, effective interviewing is a professional undertaking that requires specific training. UNODC is currently developing an online training course on effective investigative interviewing in cooperation with the Norwegian Center for Human Rights, and my colleague Gisle will speak after me a little bit about this. This e-learning course will be available from June 2021. The modules are designed to teach investigating officers what an investigative interview is, and how the usage of this methodology enhances the chances of retrieving accurate and reliable information that will stand in court. This leads to an increase in effectiveness of investigations and a decrease in miscarriages of justice. The course is composed of 2 self-paced modules, which last approximately 60 minutes. The current version is in English, and we will also translate the course into several other languages in the future. As you all might know, effective investigative interviewing has 5 phases: planning and preparation, engage and explain, free account, closure, and evaluation. UNODC e-learning modules guide the learner through each step of the investigative interviewing process. This is done through various animated scenarios. These scenarios and exercises replicate situations police officers may face in their work and explain not only what they should do in such situations, but why they should do so in order to retrieve reliable and accurate information. The modules also include other interactive exercises, which encourage the learner to reflect on their own context and what they already know. This includes exercises in which the learners can type in their ideas, and after the submission, they can compare it to a pre-given answer. And as seeing once is better than hearing 100 times, I would like to invite you to watch a 2-minute video about the UNODC's e-learning course on effective investigative interviewing. Please note that the animations you will be seeing in the video might change while we are finalizing the module.
Thank you very much, Michaela, for the presentation. And Excellencies, ladies, gentlemen, it's a privilege and pleasure to be with you today. We also want to express our gratitude towards UNODC for our collaboration on this e-learning course. It's been a long-standing ambition for us to try to reach more people faster. Happily enough, this comes as a result of the fact that demand for effective interviewing training is increasing globally. And that takes me to my second point, which is on the principles. And I think the principles will be key in terms of guiding the development of training and also policy on the implementation side of effective interviewing. A second key issue is that the principles will also ensure the integrity because this is a practice that is spreading fast across the world. And that means that if without principles, without a sort of set of standards that are embodied in the kind of training that UNODC will now deliver, it means that practice can vary much from one place to another. And I think the principles will be key in preserving the integrity of the practice that we now call effective interviewing, which is interchangeable with investigative interviewing in this case. And I think I will leave it at that, because I think many good things have been said already, and I'll leave some time for questions, but thank you very much.
Thank you to both Michaela and Gisle for this very interesting presentation on the training, and especially for the video as well. I think this e-learning module on investigative interviewing is very seems to be very user-friendly, very interactive, and really putting things into practice and own reflection. And I think this will be an excellent complementary to the principles. And as Gisle said, this will go hand in hand, reinforcing each other for the implementation of the principle. I would also recall everybody that you can ask questions on the Q&A in writing. We will have one more presentation, but hopefully we have some time for answers and Q&A after. I would now like to give the floor to Mr. Gideon Kimulu, who is the head of the Bureau for Interpol in Nairobi, but is also the head of the Secretariat for the East African Police Chief Cooperation Organization, EPCO, who has developed standard operating practices on interviewing. And I think he will be really interesting in hearing how the principles can be implemented in this region in East Africa. Mr. Kimili, you have the floor.
Thank you very much for giving me this opportunity. Your Excellencies and dear participants, let me adopt the protocols which were used earlier, because I may be wrong in my salutations. As you have been told, I'm the head of the Regional Bureau and the Chief Executive Officer of the IAPCO Secretariat. I'm in charge of 14 countries in the Eastern Africa, and I mainly coordinate law enforcement issues, especially on issues touching on transnational organized crimes and terrorism. When I look at this document of principles of effective interviewing and investigations and information gathering versus the SOPs we have, this is a document which is speaking very well to this region. And it is very, very relevant to us here in the East African region. As it has been said by Your Excellency, the Ambassador, of course, we find in most cases the weakest link in the chain of the judicial process or the prosecution of criminal cases is normally at the law enforcement stage. And speaking as as an investigator, I have a background in prosecution. I've been a prosecutor and also a criminal investigator. When an investigator goes to a crime scene or starts an investigation, there is a balance between expediency for results and, of course, following the protocols and the human rights of the witnesses and the suspect in the criminal case. But of course, if expediency and the results take the upper hand, you are likely to jeopardize the whole process of the judicial process. So in this region with HAPCO, we have developed several SOPs. We have the common standard for policing in this region, and we have SOPs on interviewing. But I want to look at this document and how it speaks to those other documents. And I really appreciate where the emphasis on this document is laboratory-based interviewing versus coercive method of getting information. And again, the emphasis here is not only getting the information for purposes of evidence, but even for tactical and strategic purposes. And when I coordinate TOCs or transaction organized crimes in this region, one weaknesses we normally find is that we don't get the barons, we don't get the big fish. We normally get the foot soldiers. And I think the biggest problem why we don't get to the big fish is because of the approach we normally have in getting the information for purposes of prosecution or for evidential values. But if we are to take the approach which has been given by this document, where we have report-based interviewing, we are likely to get very good information for strategic and tactical, and that can be used to get to the big fish. I think it is very clear that coercive interviewing and the torture is counterproductive. It doesn't help anybody. It doesn't help the interviewer. It doesn't help the prosecutor. It doesn't help the process. And therefore, this is the high time we thought, especially in this region, we change from that coercive, intimidating method of questioning to report-based interviewing. And how do we do this? I want to look at three things: training, accountability, and the implementation. In this region, we need to have training for the law enforcement officers on effective interviewing. And that is a very comprehensive process where you train the officers in every aspect of report-based training. And I wouldn't be very happy if this can be regional approach, not national approach, so that we can have a wide coverage and also disseminate the information to big areas. I wouldn't also have it involve not only police officers or practitioners, but also scholars, lawyers, but then we need the policemen for the practical purposes for that to put into practice what they have been taught by the scholars, by the lawyers, and also the human rights experts. And then, of course, one of the biggest weaknesses we normally have is that we train the low level officers and we forget the senior or the top leaders. And Sia Notiat can assist me in getting the police chiefs and having a talk to them, and the directors of criminal investigation, the prosecutors, so that as we train the young people or the young junior police officers, the senior officers can have the same training, so that when they are demanding results from the junior officers, they know the officers must follow certain protocols, must respect human rights, and that may have impact on timing of how the results, how the investigation will be concluded. Of course, this training needs to be continuous and for quite a long time, because we need to change the culture of the police forces and the services in this region. And this training must be holistic, because as we train the police officers, we need to train the prosecutors. We need also to train the prisons and department officers so that they can understand the process. But again, also the legal practitioners, they need to understand how to be trained through the same process. But then again, as we move forward after the training, we need to make sure that there is accountability every time we are carrying out any investigations or interviewing. And this the accountability can be achieved by having very clear SOPs on how you carry out the interviewing. And this should cover from the moment you have decided to have a person becomes of interest to the investigations. It also covers the witnesses as well as the suspects. And then, of course, these SOPs needs to keep on being reviewed. It shouldn't be what we call a living document, which you keep on reviewing as the environment change. And then, of course, we need clear oversight. We can have both internal and external. The law enforcement should have their internal oversight, where you check on the investigators. But also we need the oversight by the prosecutors, the judiciary, and the human rights organization, which can have access and a clear understanding of how these interviewing are being carried out. But again, we also need transparency so that what is being done is clear to everybody. Then we need a communication. Anytime a person is of interest to the law enforcement or to the investigators, he should be allowed communication to other maybe family members. We need lawyers, the doctors, and then of course we need to be very clear on keeping the recording of what is happening every time we have a suspect or we are interviewing a person of interest and during the investigations. So I think again also in the forces or in the police services or in the law enforcement officers, all the officers should also have a clear complaint mechanism. If I have an officer who is junior to me and I'm trying to push him to do what he's not supposed to do or not to follow the SOPs which will have developed, how does he raise up that issue in the hierarchy? So the other very important issue is the issue of implementation. And I think we need to customize this document. Of course, as I said, let us see how it speaks to our SOPs. And then of course, look at the environment in which we are operating in this region. And of course, have appropriate legal policy and regulatory and institutional framework, which can guide in the implementation of this document. Of course, we need judicial and interviewing authorities to be clear on how this can be carried out. And therefore, if there is, during the process, there is a complaint of mistreatment, there is a complaint of torture, there is a complaint of abuse, how do you deal with that? And it should be, I think, very holistic or very intensive, that if you are a law enforcement officer and you are involved in any kind of mistreatment, any kind of torture, and the torture is widely defined, you shouldn't face the law because, of course, we know the impact of that to the criminal justice system. And then, of course, it should be very clear to all of us in the law enforcement officers that any evidence obtained through coercion should not be admissible in any way, in any judicial process, in any court of law. And therefore, of course, finally, I would like to think about our resources and the resources being put in these institutions to make sure that we have institutional culture change, that the mindset of the law enforcement officers in this region, the prosecutors, and even the courts, the judges are changed so that we have a more humane way of getting evidence from witnesses, getting information from suspects. I think that is what I may want to talk about as of now. Again, I want to thank AFCOF because through them, we have done a lot for purposes of making sure that the policing standards in this region improved, despite the many, of course, roadblocks, the many hindrances we face, because change is not easy to bring. Thank you very much for the opportunity. Thank you.
Thank you very much, Gideon, for this very thorough and comprehensive overview of what is needed for the implementation, ranging from training to oversight, and also emphasizing the non-acceptability of evidence obtained under torture by the court, and also emphasizing how coercive interview is counterproductive. And I think your organization would be play a very important role in the implementation as well, since you have already started with your SOP. Since we are a bit short with time, we have some questions on the Q&A. Panelists will respond in writing to the questions, so you can see the responses on your screen. And I think we have to stop here. So I would like to, and I apologize for not live answers to the questions, but I would like to give the floor to Candice Welsh, who is the Deputy Director of the Division for Operations at the UNODC, for closing remarks. Candice, you have the floor.
Thank you very much, Barbara. And it's a real pleasure for me to be able to be here with you. It's been a very interesting discussion of this panel on such an important topic. I also like to thank all of the participants who've joined us. I know these online conferences are not as easy as being in person, so thank you very much. In particular, I'd like to thank Norway and you, Madam Ambassador, for your long-standing support to the work of UNODC in the area of crime prevention and criminal justice, as well as the organizers of the side event for the important partnership that we have with you. In the Kyoto Declaration that was adopted at the 14th Congress on Crime Prevention and Criminal Justice in March of this year, member states expressed their commitment to using and sharing of good practices on legally grounded, evidence-based interviewing methods, and welcome the collaboration between practitioners, experts, and other relevant stakeholders on the elaboration of a set of international guidelines for non-coercive interviewing methods and procedural safeguards. And as we've seen today, this work has already come to pass, and we're presented with such guidelines. The principles on effective interviewing are the culmination of many years of partnership between a large group of dedicated international experts. And the guidelines showcase the importance of bringing together civil society, member states, and the United Nations. The principles are an important step towards improving the effectiveness of investigations, while also protecting the dignity and human rights of all persons being interviewed, based on existing international law and good practices. However, as we have heard, the implementation of effective interviewing requires robust national measures. These include, as Gideon has just outlined, bringing the domestic legal framework into compliance with existing international law obligations and good practices, facilitating strategic police and criminal justice reform, and transforming the culture of law enforcement institutions. UNODC is already supporting a number of countries in this area within the framework of broader programs aiming at police reform and improved investigations. And we stand ready to continue supporting member states by providing legislative advice, development of specific tools and guidance, and capacity building of investigators. As presented today by my colleague Michaela, UNODC will soon be launching e-learning modules in this regard, thanks to the financial and substantive support of Norway to UNODC to their development and their rollout. Improving policing and investigations is key to allowing states to reach Sustainable Development Goal 16 and to ensure that we leave no one behind by ensuring access to justice and the protection of human rights for all. By continuous efforts to advance the evidence-based approach to policing, we can work together to reach these goals. Thank you very much.
Thank you very much, Candice. And I would just like now to close this side event saying really thank you to all the panelists for the excellent presentations, and thank you to all the participants. As you said, online side events are not the same, but I hope now you are really interested in going and reading the principles, and I think together we can work towards changing practices and moving away from confession-driven criminal justice systems and strengthen the weakest link in the chain of criminal justice to have a better and fairer administration of justice. So thank you everybody, and please connect to the APT or Norwegian Center for Human Rights website to find the principles. And the UNODC video e-learning tool will be available soon on their website. Thank you very much, and I wish you a nice afternoon, evening, day. Goodbye. Thank you.